Welcome to episode 72. Today we are focusing on recent fair housing lawsuits. So let's get started. Hello, everyone, and welcome to the Fair Housing Insiders. I'm your host, Jonathan Sarr, and joining me today is Kathy Williams. So we're looking forward to diving into some recent fair housing lawsuits and getting Kathy's expert comments and opinions on those. Just a couple housekeeping items. If you have not done so already, please remember to subscribe to our channel on YouTube and also sign up for our newsletter so you do not miss out on any of the content that we produce. For other training-related tips, as well as clips from previous episodes, be sure to follow us on Instagram at Fair Housing Institute and also on TikTok at Fair Housing Institute. Today, we are discussing recent fair housing lawsuits and what landlords can learn from them. Now, this isn't just limited to landlords, but all of us, everyone in property management. When we look at these cases, they provide real situations that have happened. There's lots that we can walk away from. So we're going to briefly summarize just 3 lawsuits today and see what Kathy has in mind for us as far as teaching points. So let's look over our first lawsuit. So this is on February 1st, 2022. The court entered a consent order in United States versus Bacchus. The complaint, which was filed on August 18th, 2021, alleges that defendants discriminated on the basis of familial status and disability related to their refusal to allow the complainant, who was living with his daughter and recovering from addiction to alcohol, to move his pregnant girlfriend and her child into his unit. So, Kathy, how did this case come to fruition, I guess, is the question.
Well, remember, this is a settlement of a lawsuit that was filed by the resident against the property management company. And in this case, I think why this case is interesting is it highlights what can happen with someone who is completely not trained to be concerned about fair housing issues. So what did this property manager do? First of all, it appears that this property management company has no policies about anything. By the way that this property manager behaved and even put in writing, in emails, in text, some absolutely outrageous statements. It's clear that he doesn't know what he's doing. And when he talks about the occupancy policy, because that's the first issue that comes up, we have a resident who has a child living in a 2-bedroom, and he wants to move in his pregnant girlfriend who also has a child. So when you think about that, how many people are in this family that are going to live together? And that would be 4. Because if you remember from past fair housing training, you do not count an unborn child because a woman's pregnant when you talk about how many people are going to live in a unit. If you do that, you are basically holding the pregnancy against the woman in a negative way, and that is viewed as familial status discrimination. So this property manager kept talking about you can't have 5 people in a 2-bedroom. When he did that, he violated the law, the fair housing law, protecting pregnant women. So that's the first thing he did. Then the second thing, which was maybe even more egregious, was he talked about the resident's disability over and over again in a very derogatory, humiliating fashion. So the resident was a recovering alcoholic. And this property manager knew about that. We don't know why or how he knew about that, but he knows about that. So in his email messages and his text messages, he called the resident a drunk. He talked about his actions in making plans to move in his pregnant girlfriend into the unit as alcoholic thinking, and basically over and over harassed and degraded the resident because of that. So when you see that in existing facts in a case, that is clear discrimination against the resident because of a disability. You might remember that an alcoholic is viewed as disabled, and a recovering alcoholic perhaps is seen as much more sympathetic to both the investigative agency and a court and a jury. So when this case got to court, there could have been substantial penalties and damages awarded in the resident's favor. This is one of those cases where this property manager should never have been employed in our industry because he clearly did not have any fair housing training whatsoever.
Yeah. Yeah, that was my takeaway. No training, no policies, and we can totally understand why so many of our clients require, before they even hit the ground, so to speak, making sure that they have fair housing training, because they don't want someone who is on a property who just could wind up in a situation like this. It's so critical, so crucial that training is employed. So thank you for that explanation. And let's go on to another one. So here's one that took place on July 8th, 2022. The court denied the defendant's motion to dismiss in CNY Fair Housing versus Swiss Village LLC. It's a lawsuit alleging that the defendants violated the Fair Housing Act by refusing to rent apartments to applicants who have limited English proficiency unless someone who speaks and reads English lives in the unit. Let me reread that. Refusing to rent apartments to applicants who are limited English proficient unless someone who speaks and reads English lives in the unit. Kathy, your comments.
We can learn a lot from this case. In this case, the Department of Justice, who was not a party to the case, this is a case brought by the New York City Fair Housing Agency against this landlord. And during the case, the Department of Justice filed a brief explaining why the federal government is concerned that a landlord would have a policy requiring all of the residents to speak, read English. And they make a very good argument that in doing so, what is happening is a disparate impact against residents who are of a different national origin than someone from the United States. So what they're explaining is, while language is not a protected category, it is so closely related to national origin that you absolutely are discriminating against people of various national origins by having a policy that you can't live there unless you or someone in the household can speak and read English. So the lesson to be learned is that is going to be an illegal policy, and you want to make sure you don't have anything in your policies that looks like that.
Yeah, for sure. It's like what we have in our courses, that big red X. Don't do that. Stop. Okay, very good. So one more lawsuit that we'd like your comments on, Kathy. So this one, May 17th, 2022, the U.S. Department of Housing and Urban Development entered into a consent order with a Baltimore, Maryland condominium company, Scarlet Place Residential Condominium Incorporated, and its management agent, Brody Management Incorporated, because these respondents refused to waive the property's occupancy policy and permit the two-bedroom condo to be rented to a family of 8 while a child of the family received a bone marrow transplant in a nearby hospital. HUD viewed this refusal as a failure to provide reasonable accommodation to the family. So again, how how did this case come about, and what are some lessons that we can learn?
Well, this is a hard one for me to talk about or justify, because the case arises in a very sympathetic manner. We have a little boy who is very ill and needs a bone marrow transplant from a medical center very close to where this condominium was located. And the entire
Mhm.
family is moving up to live in this area around the medical facility so they can be there and support the child as he goes through this very difficult, long process. Um,
Yeah.
and they find this a condominium, and it's a two-bedroom condominium, and they're a family of 8. Now, presumably for a while, one of them is going to be receiving treatment, so won't be in the unit, but surely he'll be coming home and will be going back and forth to the medical center. So there will be 8 people living in this two-bedroom unit. The owner of the unit is fine with that. It's the board of the POA that is against
Right.
it, and also the management company. And so they fine the family for agreeing to house this family of 8. They fine their owner and the family for permitting the occupancy of 8 people in a two-bedroom. So the question is, and this is the ultimate question, and remember, this was a settlement of a HUD complaint. This is not a decision by a judge or jury, and we don't know how that would have come out. We just know that HUD felt very strongly that by refusing to waive the occupancy policy, this was a failure to make a reasonable accommodation because of the disability of this child. I think the lesson to take home from this case is that there may be situations where waiving an occupancy policy is a reasonable accommodation. And I can agree with that. There may be times when you may consider waiving your occupancy policy because of someone in the family's disability. Whether it is reasonable to require that this organization, this management company, permit 8 people in a two-bedroom, whether that is reasonable or not, I think is questionable. So I think had this been litigated, the defendants may have been able to put a very strong case for why that is not a reasonable accommodation. But because they settled it, it didn't get litigated. And so we won't know how it would have been answered in a trial. But we can, I guess, put you on notice that HUD considers occupancy policies as one of the many, many policies that may have to be, you may have to make an exception if it's necessary for a family that includes a member who is disabled.
Yeah. Points to ponder. That's for sure. I like how you wrap that up, even though it didn't go to trial specifically, there's still a lot for all of us to give some thought to when it comes to reasonable accommodations and where to apply those. So 3 cases, 3 very distinct situations. Appreciate your insights, Kathy. What's our takeaway? What do we want to leave our audience with as far as what they should walk away from this episode and clearly have in mind?
There are many fair housing lawsuits, cases, and settlements that happen every year. You can learn about some of those from the Department of Justice website, which we've shared with you, and some from the HUD website, which we shared with you. Some of these cases make what I would call good law that is going to apply all the time to all housing providers. Other cases are not so easy to justify, other than to point out that when there is a very sympathetic situation going on, I think what you'll find is that the investigative agencies, HUD and the many state and county and city agencies who investigate cases are often very swayed by just by their own sympathy for the situation of the resident and their family. The last case was certainly an example of that. So whether they can support that sympathetic response legally is questionable sometimes, but you certainly want to recognize that you're going to have to realize that the agency is going to take that position a lot of times and maybe adjust your response based on what they're probably going to do.
Very nice. Thank you. Yeah, lots to think about. Great cases, great show. Thank you so much, Kathy. And we know we have a lot of these cases that are posted over on the Williams, Edelstein, and Tucker website, the fairhousingfirm.com, where the blog is all specifically about cases that are out there, and getting Leslie Tucker's comments on those cases. So check that out if you haven't subscribed to that newsletter. So thank you, everyone, for tuning into our show. If you find this show valuable, love those thumbs. Give us those thumbs. Please share it with your friends. We appreciate your support. We love your feedback. If there's any topics you would like for us to discuss, please share that with us. Until next time, take care, everyone.